Good afternoon, thanks for being here. When I was a kid, I was a big fan of the Flintstones. I was also a big fan of the Jetsons. But what I really liked most of all were those specials where the Flintstones met the Jetsons. Now obviously, other than a weird window into my childhood, you're probably asking yourself, what does this have to do with IP law or patent law? And the answer is that I see my current project, where I look at the connections between patent assertion entities and claim construction as the Flintstones meets the Jetsons moment of patent law. And on this analogy, claim construction is the Flintstones. It's the old issue that's been around for a while. In fact, sometimes it feels like the claim construction debates are stuck in the Stone Ages of the early 2000s, with the same issues, the same battle lines drawn, with no acknowledgement of the significant change in the landscape of patent litigation over the past 10 years, including the rise of patent assertion entities and the concentration of now 44% of patent litigation in the Eastern District of Texas. On the analogy then, patent trolls, or patent assertion entities, are the Jetsons, the hot new issue that everyone's talking about, the exciting issue, etc. So I've written about claim construction before. I've written about issues related to patent assertion entities before, and in writing about these, I really got thinking about the question of the connection between the two. And so I'm kind of in between projects. I'm just starting my next major project. So I decided to write an essay that answers this question that's been bugging me. What is the connection between claim construction and patent assertion entities? And what I conclude is that there's three major issues in patent claim construction that have an effect. I'm not claiming the size of the effect on the rise and success of patent assertion entities. And more worrisome, if you're concerned about patent assertion entities, is that trends in the scholarship and case law on claim construction are moving in a direction favorable to patent assertion entities. So to some extent, the connection between patent assertion entities and claim construction is obvious. I even used the pun patent in my introduction, which I'm thinking of deleting. Patent assertion entities are said to benefit from uncertain and overbroad claim scope. Well recognized that uncertain and overbroad claim scope is connected to the rise and success of patent assertion entities. Well, claim scope is to some extent, or to some significant extent, determined by the rules of claim construction. So then, it's a small logical step to think that the patent assertion entities and claim construction and the rules of claim construction have some connection. Unfortunately, this logical step is overlooked a lot in the patent assertion entity debates. You don't see much discussion of the rules of claim construction and the problems of claim construction that we talk about in a lot of different areas in debates over patent assertion entities, with one big asterisk, and that big asterisk is Lindley and others on functional claiming, which we'll bracket for now and return to in a little bit. Similarly, you don't see much discussion of claim construction, of patent assertion entities and the effects on patent assertion entities in the claim construction debates. To the contrary, the Federal Trade Commission concluded in 2011 that the current claim construction doctrine is a beneficial step from the perspective of public notice and patent assertion entities. Seriously? So I want to explore three issues with claim construction that I think have a connection and an effect on patent assertion entities. The first is the claim construction split. Without going into too much detail, because hopefully everyone is aware of this, there's an outcome determinative split within the Federal Circuit's case law as to the proper approach or methodology of claim construction. Whether essentially to focus more on the general meaning of the claim term in the technical field with only limited reliance on the disclosure and the specification itself, or whether to rely heavily on the disclosure and the specification itself with only limited reliance on external evidence of meaning in the field. And this has been shown to result in different claim scope and to be a significant source of most disagreements over claim construction in the patent system. So what's the connection here to patent assertion entities? Well, the connection is when you have a split, a methodological split within the Federal Circuit as the proper approach to claim construction, this increases uncertainty of claim scope. Different parties, different actors can rely on different methodologies to reach different claim scopes with no way of really knowing what an unknown judge in later litigation will conclude what methodology they'll use and therefore what claim scope they'll come to. So my concern is a little bit that this claim construction split is overlooked. Not really, there's a lot of talk about it, but it's overlooked compared to other issues like the far less important, which I've explored elsewhere, standard of review for claim construction. And even, we saw a lot of attention around the claim construction split in 2011 when Judge Moore dissented from rehearing a bank and retractable technologies on this issue. But since then, we've begun to see less attention, more downplaying or ignoring the split, with little discussion of it, despite all the discussion of patent scope and uncertain patent scope in the Nautilus case. Little discussion of it. And even people kind of writing post-TIVA and talking about established methodologies for claim construction, despite the split. The second connection between patent assertion entities and claim construction is the continued viability within this methodological split about what I call the general meaning approach to claim construction. Elsewhere, it's been called the heavy presumption approach, procedural approach, etc. The basic idea that we should rely heavily on the meaning in the technical field, as shown through extrinsic sources, and only look to the specification for a clear disclaimer, clear disavowal, clear redefinition. The problem with this is that it downplays the intrinsic evidence, the evidence that's publicly available with the patent and prosecution history, and that's static, that doesn't change over time. By contrast, it focuses on extrinsic evidence, evidence that is generated just for the purposes of litigation, like expert testimony, or that's selected for the purposes of litigation, like external texts. The problem is that ex ante, this is difficult to predict. It is unclear what external text will be relied on, what expert testimony will be relied on. And therefore, the Federal Trade Commission, after interviewing a large number of stakeholders, concluded that from a public notice perspective, focusing on the static and publicly available patent document produces greater certainty and greater predictability of claims. Connection to patent assertion entities. Well, the general meaning approach increases both the uncertainty and breadth of claim scope, the exact conditions in which patent assertion entities thrive. And unsurprisingly, in litigation, patent assertion entities tend to make general meaning, extrinsic-based claim construction arguments. Now, the breadth issue, the idea that this general meaning approach tends to produce greater claim breadth than a more patent-focused or specification-focused approach, is largely, I think, uncontroversial. Even those who advocate for this approach agree that it will tend to produce greater claim scope. On the other hand, or broader claim scope, on the other hand, they disagree on the certainty issue. They suggest that if we just apply the the general meaning of the technical field, people working in the field can just read the patent and know what the claim scope will be because they can just apply their own knowledge or understanding to that claim scope. And what I suggest is that's theoretically 100% correct. Unfortunately, it ignores the realities of litigation in which the quote-unquote general meaning is derived from expert testimony, expert texts selected by the parties, and what you end up with is a lot of possible quote-unquote general meanings with little connection to what the term might actually mean in the field. And what do we see in terms of trends? We see trends, there's anecdotal evidence of increased use of this kind of heavy presumption or general meaning approach in case law. We see a lot of scholars, including some in this room, increasingly endorsing this approach and emphasizing extrinsic evidence, to varying extents, emphasizing extrinsic evidence over the intrinsic evidence in the patent itself. Okay, final connection between claim construction and patent assertion entities. The standard of review. Deferential review incentivizes district courts to use extrinsic evidence. If they're going to, especially after TIVA, if they're going to get deference for using extrinsic evidence, that encourages them to use extrinsic evidence, which comes with the same breadth and uncertainty problems I just discussed. It also gives more power to the district courts. It also gives more power to the district courts. This is often seen as a benefit, though question whether it is in the current patent litigation landscape where 44% of cases are filed in the patent-friendly Eastern District of Texas. The effect, greater use of extrinsic evidence increases uncertainty in breadth. I've already talked about that. More power gives patent assertion entities more incentive to choose patent-friendly districts like the Eastern District of Texas, and it gives those districts greater incentives to offer PA-friendly claim constructions. And again, the trend here, greater deference under TIVA. TIVA was widely praised. Some even criticized the Federal Circuit for not implementing it vigorously enough. So we have these three trends in claim construction, three issues in claim construction, and three trends in claim construction that are all, I would argue, benefiting patent assertion. At this point, you might say, all right, Reilly, I don't really believe you. Don't believe me? What about the targets, the most popular targets for patent assertion entities, the high-tech companies, the information technology companies, Silicon Valley, if you will? What's their position on these? Well, they agree with me on each one of these issues. The claim construction split is a major contributor to uncertain patent scope. Absolutely. In a series of briefs in TIVA and Lighting Valves, a wide variety of these kind of information technology, high technology, however you want to call it, companies argued that the claim construction split is a major contributor to uncertain patent scope. Second, that the general meaning approach creates uncertain and overbroad claim scope, and that therefore an approach focused more on the patent and the specification is preferable. Yep, they agree. Third, deferential review will increase uncertainty and breadth of claim scope and provide PAEs greater return from choosing favorite districts. Yep, they also agree with me on that. And they don't draw the explicit connection between their positions and patent assertion entities, but it's fairly implicit in their briefing, and they do talk about uncertain claim scope and patent assertion entities. So, turning from the descriptive to the normative, the question is, what does this all mean? And to a large extent, what this means depends on your view about patent assertion entities. Do you think they're good, bad, or neutral for the patent system? I don't answer that. I don't take a position on whether patent assertion entities are good or bad for the patent system. If you're not concerned about patent assertion entities, my essay is probably not going to tell you much. I would say, and I have said it other places, that I think the current claim construction trends and issues are problematic in their own right, fully unconnected patent assertion entities. But if you're not concerned about patent assertion entities, this essay is not going to tell you much. If you are concerned about patent assertion entities, then maybe we need to be spending more time paying attention to claim construction rules and the incentives and results they generate for patent assertion entities. Now, I'm not suggesting that claim construction is the sole reason that patent assertion entities have thrived over the past decade or so, nor am I suggesting that changing the rules of claim construction or altering claim construction will totally resolve issues. All I'm saying is it's a contributor. It's something that should be part of the patent assertion entity debate. And perhaps we can resolve these issues in ways other than changing claim construction rules. So for example, Professor Mark Whatleys has his proposal on functional claim. Basically, functional claims in software patent should be limited to the disclosure and the specification, to the disclosed structure and the specification. And this may be a way to deal with these same issues I'm seeing without changing general claims construction rules. Why is that? Because what his proposal essentially does, the effect of it, is to exempt software functional claims from normal claim construction rules. The split of methodology wouldn't matter, the general meaning approach wouldn't matter, because he says, look for functional claims, look to the specification. Essentially do a patent-focused methodology. Now, I'm totally sympathetic to this. Can't rule out the possibility it's the solution, but I'm not 100% convinced in that it doesn't address necessarily all patent assertion entity claims. And second, claim drafters are good and creative. Any rule based on the nature of the claim, I think is easy to get around for skilled claim drafters. A couple other thoughts. There's another connection between claim construction and patent assertion entities. All these proposals out there right now that focus on the merits of the claim as a way of combating patent assertion entities. Heightened pleading requirements, fee shifting, Rule 11 sanctions. They all depend on saying that the claim was weak, frivolous, something along those lines, often at the time of filing. But because of the uncertainty and breadth of claim scope, combined with the presumption of validity that helps you on the validity side, it's very easy for a patent assertion entity to identify a good claim construction position, or a viable claim construction position, and therefore a viable litigation position. All right, last thought, which is, what does this mean for those interested in claim construction? Well, maybe the current trends, current rules, current issues in claim construction are fully justifiable on their own without regards to patent assertion entities. I doubted this elsewhere, but that's perfectly fine. All I'm saying then is that the positive consequences for patent assertion entities need to be taken into account in the cost-benefit calculus for any kind of claim construction rule. And then the last thing I want to point out is I'm not suggesting we should change claim construction rules just to combat patent assertion entities, or that we should have special claim construction rules for patent assertion entities. This proposal, this essay, is more in the vein of Limley and Malamed's missing the forest through the trolls, which is that patent assertion entities are a symptom of larger problems with the patent system. They are not the cause themselves of problems with the patent system. They're a symptom of larger problems with the patent system, including our rules for claim construction. So I look forward to questions. John.
I mean, I guess I can't recall you mentioning the Phillips case in this. And under Phillips, I view much of this as kind of second order. The Phillips case was in response to this kind of split by, pointed out, and in part that was pointed out by Wagner and Patrick by others, with a real move toward emphasis on extrinsic evidence in terms of dictionary definitions. And the en banc court made pretty clear there that the specification was the #1 thing you look to. So it's the intrinsic evidence, which is, upheld by the Supreme Court in Teva, where Breyer's opinion suggested that, well, we expect, as suggested in Markman, that most of the time you're not going to need to go to this kind of extrinsic evidence on which you're going to rely. So, I mean, I guess, one question I have is, should we, these might be rules, but under Phillips, many of them seem to me like kind of second order rules, which might mitigate the effect they're having.
Well, so Wagner and Pathebridge have a follow-up paper where they find that, and maybe I'm missing the question, but they find the same kind of claim construction split exists after Phillips, where there's a line of cases that has developed after Phillips.
Yeah, well, I can't remember when that second paper was. We have a lot of new judges. You expect, as with anything, you have to wait till some people get carried out on their backs for what they're doing really to change. But for the district court judges getting, I know in practice, we've been, before Phillips, you were running around, I was sending paralegals to the BU science libraries, the MIT science libraries. I want every dictionary definition of this you can find, and I'm going to pick the ones I produce. After Phillips, there was a dramatic change of what we're doing. We're still getting dictionary definitions, but the main arguments were going to be based on the specifications. So what the attorneys were doing, just feeding into what the courts are using for the decision seems to change.
Okay, so the Wagner and Pathebridge is 05 to 07 is their follow-up study, essentially. But then you've also, and that's the last empirical paper on this. There's also anecdotal evidence that you're seeing a shift back to the Texas digital type approach coming up in a lot of these cases, where we're moving back towards more emphasis on the extrinsic evidence, and you see that in Judge Moore's retractable dissent, where she essentially says, because she's had several of these opinions, where she essentially says that Phillips supports an approach that more emphasizes the general meaning in the technical field. So I would suggest, and others have suggested, practitioners and scholars, that the split still exists there, and that Phillips, in my view, isn't being faithfully implemented. We can talk about that.
So one of the things that's attractive about the Lemley and Melamed article relative to saying take into account patent assertion entities in claim construction is that if you take into account patent assertion entities, you might take down rules that are just generally beneficial to patent holders, and some of those patent holders are not patent assertion entities. And so if you can sort of come up with some sort of more fine-grained approach that is addressed to the problem rather than, so that's kind of that's just kind of a general reaction that I have to this, is that why would you want to take on big swaths of patent law out of concern for patent assertion entities if you're going to be, throwing out the baby with the bathwater?
Yeah, absolutely. And if you agree with the other trends in claim construction, that's an easy argument. Yeah. That's a very solid argument, which is, hey, these things are good for other reasons, so let's find a more tailored solution. But I do think that they still has to be part of the discussion. Now, I've done in other work, and this is where this comes from, explanations or analysis of why I think the trends, all of these trends, are problematic for in their own right, on their own basis. But absolutely, if you think that that these other claim construction rules are good on their own, then the obvious answer is we should be looking for something targeted at patent assertion entities, specifically if we think they're bad, and if we can find something that will be effective.
Minute 20.
So,
Sorry.
Just one thing to consider is I think I've seen data that showed that the reversal rate for Eastern District of Texas is on par with other district courts.
Yeah.
And so that may suggest that claim construction isn't something that's really contributing or creating a problem for patent assertion entities. So the other thing you might consider is I wonder if HEVA may have counterintuitively an opposite effect in that because the Federal Circuit wants to maintain control over patent construction, they will focus to the detriment of extrinsic evidence. They will focus on intrinsic evidence and in some ways make it a little bit more predictable because by maintaining control, they want to make sure that an extrinsic, something based on extrinsic evidence isn't going to contradict what they see as the right construction based on the intrinsic.
Yeah, so on the second point, absolutely, and I do mention that in the paper at the same time. I say district courts might have incentive to rely on extrinsic evidence. The countervailing force is this could actually finally force the Federal Circuit to resolve the split in favor of intrinsic evidence and have it stick. Because again, I'd argue it didn't stick after Phillips. On the first point, yes, there's a lot of complicated reasons about the Eastern District reversal rate that I could talk to you offline and I've gotten into it in other work. But the other empirical work out there by Chris Katropia shows that when the Federal Circuit reverses claim constructions, it tends to be in situations in which the patentee won below. And it tends to be in industries like information technology, business methods, etc., that tend to be patent assertion entity heavy. So deferential review, that's eliminating some of those reversals, would be eliminating reversals of patentee wins below in in patent assertion entity heavy fields.